SJC-12299, Raymond P. Vinnie v. Sean Medeiros.
Mr. Vinnie, good morning. Keep your voice up if you would, and you've got 10 minutes, sir.
Good morning.
Morning.
We'll hear from you, sir, with regard to your claim. If you wish to be heard.
You may proceed.
You just get cut off.
Hello?
Yeah, you may proceed.
Good morning. Who am I speaking with?
You're speaking to the justices of the Supreme Judicial Court.
Good morning, Justices of the Supreme Judicial Court.
Good morning.
My name is Raymond P. Vinnie, and I'm the appellant in this case. And if it would please the court, I'll refer to myself as the appellant. Thank you.
You may. Go ahead.
This is a case of first impression, which has to be presented an ultimate issue in this habeas corpus proceedings under 248 Section 1 on whether the December 16, 1993 minimus ordering the appellant to imprisonment for common law murder simpliciter is lawful, even though common law murder was repealed in 1858, enactment of 265 Section 1. In the average case, a void minimus may only be corrected by a valid and lawful judgment, which attained its genesis from the valid and lawful jury verdict, which is affirmed and recorded in open court under the sanction of the trial judge. However, the appellant's case is not that average case, as there is no valid and lawful verdict affirmed and recorded and available to correct the void minimus. And therefore, the superseding judgment and minimus that order his unlawful imprisonment is by operation of law likewise rendered void and entitles him to immediate release. This is the exact illustration of the aforementioned void verdict underlying the void judgment and void minimus as follows. Clerk, Mr. Foreman and members of a jury, have you agreed upon your verdict? The foreman, yes, we have. Clerk, on docket 95738, Commonwealth versus Raymond P. Vinnie, on an indictment charging murder, what say you? Ended at the bar, guilty or not guilty? The foreman, guilty. Clerk, you upon your oath do say that the defendant is guilty, so say you, Mr. Foreman? The foreman, yes, I do. Clerk, and so say all of you members of the jury? Jurors, we do. As apparent from that verdict, it fails to be in conformity with the well-established ritual in Commonwealth versus Tobin. And that is that a verdict is not a verdict until it's affirmed and recorded. This court recognized the long-established rule of law in Tobin in Commonwealth versus Dunn, that the only verdict which can be received and recorded as a complete and valid verdict upon which a judgment can be rendered is an open and public verdict given in and assented to in open court as a unanimous act of the jury and affirmed and recorded and entered of record in the presence and under the sanction of the court. In conclusion, there is no verdict as long as there is any contingency or uncertainty in the finality of the jury's determination. The verdict in the appellate's case is unlawful because in 1858, common law murder was abolished in Massachusetts and is no longer a punishable crime due to the enactment of 265 Section 1, which repealed the common law on the subject. Actually, 263 Section 9 provides that a person shall not be punished for a crime unless he has been legally convicted thereof by a court of competent jurisdiction over the cause and over the person. law and justice would seem to require that the appellant is entitled to immediate release from unlawful imprisonment forthwith because of no valid verdict in the case at all. And I think that is pretty much sums up what my hopes that the court will agree with.
Okay, if there are no further questions, you have nothing else, then thank you, Mr. Vinnie, and we will now hear from Mr. Haskell. So please stay on the line.
Good morning, Your Honor. May it please the Court. My name is Eric Haskell. I'm an Assistant Attorney General. We represent the respondent in this Chapter 248 habeas proceeding, Sean Medeiros. I think our points that we'd like to leave the Court with are threefold. First, a challenge of this type, really going to the content of what a minimus says, isn't a type that's appropriate for a habeas proceeding under Chapter 248, but rather ought to be the subject of a motion to correct the record under Criminal Rule 42. Second, there's nothing wrong with this minimus, that by indicating the crime of conviction as murder and the statute as 265 Section 1, that this minimus did everything that it needed to do. And then third, that if this court does perceive an error in the minimus and does deem a habeas proceeding as the correct way to go about it, the appropriate remedy is simply to correct the minimus to accurately reflect the crime of conviction and the sentence was imposed, and the transcript that the court has before it as part of the petitioner's record appendix explicitly indicates that the crime of conviction was first-degree murder and that the sentence imposed was life without the possibility of parole. So, unless the court has questions.
I have a question for you.
Yes, ma'am.
Yeah, given the fact that this is basically an appeal of Judge Connor's ruling, right? Wouldn't he just appeal that in the ordinary course as opposed to bringing it to the single justice?
The procedural path that brought the case here was a little, I think, unusual. What the petitioner did was actually filed his 248 petition in the county court in the single justice section. Justice Lowy referred it to the Norfolk Superior Court, and the Norfolk Superior Court, rather than initiate a new civil action for this Chapter 248 petition, appears to have captured it under the criminal action, under the original indictment. After Justice Connors denied relief, the petitioner filed essentially a motion to reconsider in the county court in the single justice section, and after Justice Lowy denied that, that's the order from which the petitioner noticed an appeal. So it's an odd procedural posture, but I think all roads lead to the same place in this case.
And that, well, let me make sure I understand.
Sure.
Am I correct that when this court back in 1998 denied his appeal, I don't see any reference to the claim that the jury did not make known what degree of murder it had found? Was that ever raised before or considered before?
No, it wasn't. And as a matter of fact, there was a very obvious reason for it not to be raised. Really, the flagship issue in the direct appeal back in 1998 was whether anybody, the court or the defendants, or Mr. Vinnie's lawyer, had committed error by declining an instruction on second-degree murder. In the trial, the only instruction that the jury got was first-degree murder. That's what he was convicted of, and so there was really no possibility of confusion, no room for dispute that the conviction came back at first-degree murder.
So I see it is addressed, but it's addressed with regard to the claim that counsel was ineffective for failing to ask for a second-degree murder.
That's right.
All right, thank you.
Thank you.